Hi, I'm Labe Richman, and I'm a post-conviction attorney in New York City, and I do post-conviction work in New York State, and in the federal courts. Today I'm going to be talking about 440 motions. 440 motions are really a blessing in New York, and the reason they're a blessing is because you can make them at any time. You could try to get your conviction back or your plea back really right after you plead guilty and get sentenced, or you could do it 20 years later, 30 years later, 40 years later. There's no limit on when you can do it. Now, obviously, if you wait too long, the courts are going to be reluctant to help you out in that regard if you just waited and really took advantage of the situation, because after many, many years, the evidence is going to be stale. But you really can do it. There's no bar. And there are many ways to attack a conviction, of course. One is an appeal, where you file a notice of appeal right after you're convicted, or you file a motion for a late notice of appeal within the first year. But 440 motions are not appeals. 440 motions are motions that go back to the court that handled your case in the lower court. And it is true that it's better when you do a 440 motion that it be based on facts which are off the record. In other words, things that were private between you and your attorney, or evidence that wasn't brought out at your trial. Because if it's on the record, if it's in the transcripts of your case, then you really should have raised that issue on appeal. Now, that doesn't mean that you're barred from raising on the record issues, because you can raise them if you can justify why you didn't appeal. And there are often many reasons why people don't appeal. They thought they waived the right to appeal certain issues. They didn't know they had the issue. They were told the wrong information about their appellate issue. Their attorney didn't advise them of the right to appeal. And maybe they didn't know the immigration consequences or the collateral consequences of their conviction. And it wasn't until they found out that information that they realized, oh, I should have appealed. Let me do a 440 motion to try to attack my conviction. Now, I want to end this video today by talking about the risk of doing post-conviction work. And that could be an appeal, or it could be a 440 motion to attack your conviction in the trial court. Now, if you pled guilty, you got a deal. You got a plea bargain usually. So if you say, hey, I want to undo my conviction, you're going to undo the bad part of your conviction, and you're also going to undo the good part, which is your plea bargain, meaning you got less time, maybe you had to pay less money, you didn't get probation, you got a conditional discharge, or whatever. You lose that benefit. Now, obviously, if the case is very, very old and you're able to get it vacated, there's probably not much of a risk, because the prosecutors probably don't have that much evidence against you that they could retry you. But if the case is more recent and you try to get your plea back a year after your conviction, it's quite possible that they could take you to trial and give you much more time than you got on your plea. So the risk of doing post-conviction work is something that's very important, and it's something that you should consider with your attorney. Now, there are many immigrants, and there are many immigrants in my practice, who want to get their plea back because they didn't realize the immigration consequences of their plea. And I'm going to be making another video about those issues to try to educate immigrants on what their rights are in trying to get their plea back. Thank you so much for listening to this video, and if you have any questions, contact me at labe@laberichman.com, or you can look on our website, which is www.convictionattack.com. Thank you very much.